Good morning. Thank you for joining us on this live webinar, streaming live on Facebook pages. My name is Advocate Muhammad Abduroaf, and today we'll deal with a topic regarding child custody, child maintenance, and divorce. You will notice for the last week, Monday to Friday, we try to have this video every day in order to allow people to pose questions live to an advocate dealing with family law matters and to receive immediate answers to it. The aim of these videos and these webinars are to give the public an opportunity, those who do not have access to legal representation or legal services, to pose whatever questions you have live, and I'll try my best to answer it for you. Please note that I can only see live questions that are posted on the Advocate Muhammad Abduroaf Facebook page. I'm looking at it now. If you are not viewing this live webinar via the Advocate Muhammad Abduroaf Facebook page, please visit it. Alternatively, you can visit www.abduroaf.co.za/live, and there is a redirect link that will take you to the relevant page. Welcome to this webinar, and let's start off with this topic regarding child custody, child maintenance, and divorce. Last week I dealt quite in depth regarding the issue concerning child maintenance, what happens during the lockdown, if parents lost their jobs and so on, what can you do, what should you do, and what should you not do. The quick answer is you should continue paying child maintenance. If you do not have any income, sell your assets, sell your car, sell your house in order for you to support a child and to maintain a child. There are many videos dealing with that was posted last week, so please have a look at it. It should be on the various Facebook pages. Let's kick off on child maintenance today. We're not dealing with child custody so much in detail. We might deal with that later on in this week. Let's deal with a scenario of somebody that cannot afford to maintain the child any longer. He or she lost their job. What should he or she do? My advice to anybody, if there is a court order in place, a maintenance order in place, either via a divorce, because a divorce order more than likely will have in it a maintenance clause, or via a maintenance court ruling. The parties appeared in the maintenance court, and the maintenance court made an order either via agreement or after hearing both parties, and it made its own order. If there is a maintenance order in place and you no longer can afford to pay the maintenance, do not leave things the way they are. You need to approach the maintenance court as soon as possible to make an application for changing or varying the maintenance order as soon as possible. The reason why I'm saying so is the longer you take to do it, it means you are longer in contempt of court. You are violating a court order. You are committing a criminal offense. If you and the other party came to a temporary agreement, for example, you tell the other party, or you mention to the other party, I can no longer afford maintenance for the next 2 months. I can only afford to pay 80% of the maintenance. Are you happy with me paying 80% for now, and I will repay you after 2 months the balance? If there is such an agreement in place, I would not recommend that you approach the maintenance court for a variation if you are intending to comply with the maintenance order 2 months later, and the other party who is receiving the maintenance amount is in agreement therewith. If that is the case, please have it in writing. Let there be some type of documentation proving that there is an agreement and the other party is willing to relax the maintenance provisions for a period of 2 months. However, if you are not certain when you will be obtaining your income again in the future, you do not know for how long you will not be able to maintain, or for how long when you will be able to adhere to the maintenance order in the future, you do not know when that will be. Under those circumstances, we advise you approach a maintenance court to vary the order for quite a few reasons. Number one, there might be a dispute between you and the other party, and he or she may now decide to go to the maintenance court. and lay a criminal complaint or a complaint of non-compliance to the maintenance order. If that is the case and that happens, then we'll have to tell the maintenance court, yes, there was an agreement, we had an understanding. Other party might say, no, our understanding was this or this, whatever the case may be, and then there's a problem. And then the court might say, but sir, you do know, or ma'am, you do know that you're in violation of the order. You had a legal obligation to comply with the order. You chose not to comply with the order, and therefore you're in violation of the order. And we do not want that to happen. If you approach the maintenance court immediately, soon after it came about that you cannot afford to pay the maintenance amount because you lost your job or something happened, immediately approach the maintenance court. If the other party decides to approach the criminal courts or lay a complaint against you, you can at least show the maintenance court or the criminal courts that I have applied soon after I find out that circumstances have changed. If you find out that you might be retrenched, or you will be retrenched, or you'll be losing your job in a few months' time, soon before that, maybe a month before that, approach the maintenance court and advise the maintenance court that I will be losing my income in a few months' time. I will not be able to afford the maintenance and so on. But bear in mind, if you lose your job, you might get a pension payout, severance packages, some lump sum payments, and so on. You might not be earning an income per se, but you will have assets. And at the same time, if you are losing your job and you no longer earn X amount of money, but you have a lot of assets, properties, cars, policies, and so on, investments. If that is the case, I would not necessarily say by default you should approach the maintenance court for a deduction. So basically you're telling the maintenance court, I lost my job, therefore my income will no longer be used to pay for the child maintenance, but I have a lot of wealth and assets which I want to use for myself, and I do not want to use it for my minor child, to support and feed my minor child. We do not want that to be the case. If you truly have no other assets to sell or to dispose of in order to pay your child maintenance after you have been retrenched, then obviously a case can be made for that. We have a question on the live chat on Facebook Live. Let's go. My husband's salary is 4,800 Rand and his ex-wife's salary is 26,000 Rand. So that's about 4 times more. She told the maintenance officer the 6-year-old's expenses every month is 7,000 Rand. He used to pay 1,200 Rand a month because that's really what he can afford. He pays 50% of clothes, medical expenses, and any other expenses. Court says he must now pay 3,700 Rand a month. Okay, how? So the query we have over here is, the specific person is asking the question on behalf of a husband who earns 8,400 Rand per month, and his ex-wife, I presume to whom he is paying the child maintenance, earns 4 times his salary, 26,000 Rand per month. And they came about that the child expenditure is 7,000 Rand per month. In my view, is the mother should pay 4 times the child expenditure as opposed to the father, who should only pay 1 because she earns 4 times more than the mother. Sorry, she earns 4 times more than the father. So I would not necessarily agree to that calculation, because if the father must pay 3,700 per month, he's paying more than half the child's expenditure, despite the mother earning 4 times his salary. And he used to pay 1,200 per month. That could possibly be right. Maybe a bit more he should pay to make it closer to a quarter of the child's expenditure. So I do not agree with that, the maintenance officer's calculation based upon what the specific commenter has stated. However, you have to look at various other aspects. You have to look at whether or not the mother has any other children to maintain. We need to look at a reasonable expenditure. She may earn 26,000 per month, but she may be paying towards other expenditures as well. It's very difficult to answer those type of questions in isolation. I can make a case out for the father and a case out for the mother. Is she remarried? Is she paying off a bond? Does that 7,000 per month, which they are saying the 6-year-old's expenditure includes, does it include school fees, accommodation, and so on. It's difficult to work it out, but I'm not giving you a concrete answer to the specific question. That will be irresponsible for me to do. But what I would advise the mother to do, or the father to do under these circumstances, is to appeal that decision if he feels that he is paying much, much more towards a minor child, considering everything. Although the mother is providing the roof to the child's head most of the time, if you work out the mathematics, he's the one losing out. He's paying much, much more towards the child. And the commenter now see it on Facebook Live, that's literally just happened in court now. I would just probably take it on appeal if he or she is unhappy with that decision. If you have any questions on Facebook Live, on the Advocate Muhammad Abduroaf Facebook page, please feel free to post it, like this commenter just done now, and I'll try my best to answer it. But let's stick to the specific question while waiting for more questions to come in. Both parents have a legal obligation to maintain the minor child, not based upon the income only. You have to look at assets. And the law does not stipulate that a parent should maintain children 50-50. It is according to their means. Therefore, if a parent earns much, much more than the other parent, then he or she must pay much, much more towards the maintenance of the child. And that is the law, and that's how it works. And at the same time, we have to look at the parent's assets, as I keep on mentioning. You might earn very little money per month with your job, but you have a lot of assets again. You have a lot of wealth. Therefore, under those circumstances, you might have to contribute much more towards a child. Because I would say it's unfair. Because let's say a mother or a father earns, let's say 10,000 Rand per month. He uses or she uses that income to maintain the child, to buy food, etc. The other parent earns 5,000 Rand per month, but owns properties, cars, policies, houses, etc. It would be unfair for the parent that earns 10,000 Rand per month to use half his salary every month to maintain the child, where the other parent maybe uses his whole salary to maintain the child, but has millions of rands in the background of assets, where the parent caring for the child using half his salary can only have 500 Rand per month to go further in life, to build up some wealth or income. The comment again said there is no other children. She's taking care of a boyfriend who lost his job during COVID. Her rent is 3,500 per month. They do not have any debt. I'm reading it verbatim from here. Then I would say the magistrate will have to explain. Usually under these type of matters, the magistrate would have to give a judgment at the end of the maintenance hearing. And after you have studied and analyzed the judgment, you can work out exactly how the magistrate came to that decision. Alternatively, if no judgment has been provided, you have a right to request written reasons for the judgment. That might be a good option for the Pacific commenter to do. Ask your husband to request from the court, or formally request from the court, written reasons for the judgment. And then obviously that judgment, you can take it on appeal. If there are any other questions, feel free. The same commenter, you're welcome to comment further. On Facebook Live, please visit the Advocate Muhammad Abduroaf page. Please like that page if possible. And furthermore, if you are not on that page, if you're on the Our Lawyer page, for example, or one of our groups that is streaming live, please visit www.abduroaf.co.za/live. It will redirect you to the proper Facebook page. If you have any questions, feel free to pose it. This is a typical example where parties will go to the maintenance court and be dissatisfied with the maintenance court's decision. The maintenance magistrate, he or she made a decision based upon all the evidence in front of him or her. They are not, they make mistakes. They're not infallible. If you are unhappy with a decision, my advice to you is, please take it on appeal. That's why we have appeal courts. Take it to the High Court. And at the very least, request a written reason for the judgment, because the magistrate will have to explain in the written reasons why he or she came to that decision. And I feel the decision is a bit unfair based upon the information given. I might change my mind once I see all the information, once I see the father's financial circumstances and the mother's financial circumstances and the reasonable needs of the child. But that's not before me, and I can only present my answer based upon the information given to me. So let us now move on with the issue regarding child maintenance, child custody, and divorce. When a court deals with a child maintenance matter in a divorce hearing, it's quite difficult because the court, it seems to me, do not really want to deal with maintenance matters in a divorce type of setting. The first issue that must be resolved is, number one, is has the marriage illegally broken down? That could possibly be very easily worked out. But for a court to spend days and days dealing with a maintenance inquiry, which should be best dealt with in a maintenance court, I would say for the parties to resolve a divorce, do not deal with the maintenance matters in the High Court or in the divorce court. It can be extremely expensive because the lawyers are now spending hours arguing whether or not an expense is reasonable or not. My advice would be, if the entire divorce process can be resolved, the child custody issues, the primary care, guardianship issues, and so on, then reserve the right to deal with a maintenance matter in the maintenance court. Much cheaper, much more efficient, as opposed to dealing with a matter, spending thousands of rands on lawyer fees in the divorce court, whereby you might get only a few hundred rand more, or you might even lose a few hundred rand, whereby you spend thousands of rands. It might not work out, and that money could best be used for the minor children. There are no further questions. On the issue regarding child custody and maintenance, I get a query many times where people say, I'm paying child maintenance, therefore I believe I should have more contact rights to my child. The two issues are separate. You cannot argue that because I'm paying more child maintenance towards my child, I'm entitled to have more contact rights to my child. If you apply that type of logic, then the opposite should actually apply, because if you are spending more time with the child, you're spending more money on the child, therefore you should pay less child maintenance. Or a parent who pays no child maintenance must say, because I'm paying no child maintenance, I should have full custody over my child. So there's no logic behind those type of arguments. The law is simple. Child maintenance matters and child custody issues are separate issues. You can have a scenario where a father or a mother pays all the child maintenance, but he or she will have no custody rights to the child. He or she will have no right to see the child. Let's say we have an example where a parent is, abusive towards a child, unfortunately, drunkard, a drug addict, and so on, during contact sessions with a child, whereby supervised contact might not be a good idea because of the child being afraid of the parent and does not want to be in the parent's company, etc. Let's say the child is maybe 17 years old, finalizing school, and had a very traumatic relationship with the other parent, and wants nothing to do with that parent. Does not want to see the child. The court might determine, no, that is best for the child. We don't look at the parent's situation. Under those circumstances, the court might say, sir or ma'am, you still have a legal obligation to maintain the child. He or she might be ordered to pay all the child's monthly expenditure, school fees, clothing, accommodation, medical, and so on, but have no rights of any contact with the child. You see, we look at what's best for the child. And at the same time, and some people might not want to accept this principle, and I'm using maybe, for example, a father here, whereby a father might have no money, no income, no assets, as the case may be. But he or she he will have unlimited contact with the child. Unlimited, for argument's sake, collect the child every morning, take the child to school, bring the child back to his place, and drop the child back at the mother's home, and so on. Half school holidays, every second weekend, and so on. He pays no child maintenance because he cannot afford it. And he proved he cannot afford it. He tried every day to find a job, he cannot find a job. But it is in the child's best interest if he continues to have contact to the child despite him paying no child maintenance. And under this scenario, the mother would be the one who pays all the child expenditure. And he comes every day and he collects the child and drops the child back the evening by the mother. And maybe because the mother is working and and she would not be able to care for the child during the day. I think that's it. We're now heading into 20 minutes. I'll be having this video again tomorrow. If you are watching via our Facebook pages, please like the Advocate Muhammad Abduroaf page. And if you have any questions, you can type it out tonight already. And tomorrow, when we're back online, you can just copy and paste it, and I'll try my best to answer it. Please share this video if you can. Thank you very much, and have a lovely week ahead.